In May of 2017, the St. Petersburg International Legal Forum Private Law Prize was presented. This global award is tasked with recognizing the highest academic class of the winner, while its financial component, 10 million rubles, is intended to help with the implementation of research ideas of international importance. The prize's visual style was created by the world-famous designer Karim Rashid. It is made of crystal glass by renowned Bohemian artisans. The award consists of two vertical triangles with their tops touching, symbolizing the two opposing viewpoints. Rays of light that go through these triangles meet at the center of a horizontal crystal block where they refract, visualizing the process of truth-finding as a basic principle of jurisprudence. The expert committee of the St. Petersburg International Legal Forum Private Law Prize consists of the world's most prominent jurists and academics who set the trends in today's legal science. Professor Anton Asoskov, leading Russian scholar conducting research on various private international law issues. He has written extensively on Russian civil and commercial law, comparative law and international private law, with over 70 published articles in diverse legal journals and several monographs. Professor Yurgen Bazedov, a world-renowned scholar who has extensively written on various aspects of private international law and European private and economic law. Professor Mikhail Joachim Bonnell, well-known author of numerous publications in the field of transnational business law and international uniform law, consultant to the International Institute for the Unification of Private Law, UNIDROIT, chairman of the working group for the preparation of the UNIDROIT Principles of International Commercial Law, now in their 4th edition, 2016. Professor Rémi Cabriac, renowned specialist in contract law and comparative law, both in France and abroad. He is also an internationally recognized expert on codification of civil law. Professor Timothy Endicott, author of numerous works on jurisprudence and constitutional and administrative law. His works on legal interpretation made a significant contribution to the academic discussion. Professor John Finnis, Fellow of the British Academy, Queen's Counsel, a legal philosopher and author of Natural Law and Natural Rights, a seminal contribution to the philosophy of law and a restatement of natural law doctrine. Professor Sir Roy Good, Commander of the Most Excellent Order of the British Empire, Queen's Counsel, Fellow of the British Academy, Emeritus Professor of Law in the University of Oxford, and author of many widely used textbooks in the field of commercial law. He has played a leading role in the development and conclusion of a number of international conventions and protocols. Professor Akira Kawamura, past president of the International Bar, a well-known Japanese lawyer, corporate auditor, and board member of a number of Japanese companies, an influential member of the Japanese Bar, and chairman of the Japan Federation of Bar Associations, Foreign Lawyers, and International Legal Practice Committee. Professor Takeshi Kazima, chairman of the Expert Committee, a renowned specialist in civil procedural law who contributed to the understanding of its reception. He served as professor of Chuo University, a visiting professor at Aix-Marseille University and Frankfurt University, and was also a visiting fellow at the Australian National University and the University of Michigan Law School. Professor Vincent Lamanda, former first president of the Court of Cassation of France, which is the highest judicial function in France, a renowned lawyer who contributed to the development of various legal issues, Chevalier of the Legion of Honor and of the National Order of Merit. Professor Ken Oliphant, head of school designate, University of Bristol, a renowned scholar who's made a significant contribution to the development of English and European tort law. Professor Marta Pertegas, Deputy Chairman of the Expert Committee, a scholar who possesses an extensive knowledge of private international law and is a renowned expert in this field. Professor Enrico del Prato, Dean of the Law Department, Sapienza University of Rome, author of numerous publications on various issues of private law and in general theory. Professor Wei-Sin Shen, a Chinese scholar who has extensively published on various aspects of property law, contract law, and bioethics and health law. Professor Graham Virgo, Pro-Vice-Chancellor for Education, University of Cambridge, one of the leading academics in the law of restitution in the UK. Professor Jay Westbrook, one of the most distinguished US scholars in the field of bankruptcy. He has been a pioneer in this area in two respects: empirical research and international comparative studies. The world's top-ranking universities were given the right to propose candidates for the St. Petersburg International Legal Forum Private Law Prize. Based on publicly available ranking information, a list of leading law schools and R&D centers was drawn up, and 82 deans of legal faculties on 5 continents received invitations to nominate academic works. Dozens of papers have been submitted for the 2018 prize. Only 21 met the competition criteria. The universities are listed in alphabetical order. The Asian Academy of International Law nominated the academic work Shareholder Protection Reloaded, redesigning the matrix of shareholder claims for reflective loss by Julian Chase and Lisa Zhou-Yui Lee. Brooklyn Law School nominated the academic work The Private International Law of Secured Transactions, Rules in Search of Harmonization by Neil B. Cohen. Columbia University nominated the academic work Securities Class Actions Against Foreign Issuers by Merritt B. Fox. Duke University nominated the academic work Misalignment, Corporate Risk-Taking and Public Duty by Stephen L. Schwartz. Sapienza University of Rome nominated the academic work Exclusive Jurisdiction in Intellectual Property by Benedetta Ubetazzi. Leiden University nominated the academic work CJEU's Decision in Nelson and Others in light of the exclusivity of the Montreal Convention by Sonia Radosevich. Lomonosov Moscow State University nominated the academic work Comparative Corporate Law by Yevgeny Sukhanov. Max Planck Institute for Comparative and International Private Law nominated the academic work Trademark and Unfair Competition Conflicts by Tim Dornis. McGill University nominated the academic work Droit commun des biens, perspectives transsystémiques by Yale Emmerich. Pontificia Universidad Católica de Valparaíso nominated the academic work El concepto de crédito en el derecho chileno by Alejandro Guzmán Brito. St. Petersburg State University nominated the academic work Il contratto di affidamento fiduciario by Maurizio Lupoi. University College London nominated the academic work Accessory Liability by Paul S. Davies. University of Antwerp nominated the academic work The Disorderly Infiltration of EU Law in Civil Procedure by Talia Kruger. University of Bristol nominated the academic work The Europeanization of English Tort Law by Paula Gilliker. University of Cambridge nominated the academic work Sovereign Defaults Before Domestic Courts by Hayek Kupelians. University of Cape Town nominated the academic work Escaping the Schifrin Shackle Through the Application of Public Policy. An analysis of 3 recent cases shows Schifrin is not so immutable after all by Lauren Cohn. University of Montpellier nominated the academic work Droit de la Distribution by Didier and Nicolas Ferrier. University of New South Wales nominated the academic work Money Awards in Contract Law by David Winterton. University of Nottingham nominated the academic work The Lex Mercatoria in Theory and Practice by Oshoya Tot. University of Oxford nominated the academic work Proof of Causation in Tort Law by Alexander Steele. University of Zurich nominated the academic work Bail-in and Total Loss Absorbing Capacity, TLAC, Legal and Economic Perspectives on Bank Resolution with Functional Comparisons of Swiss and EU Law by Yves Mauchly. Each work was reviewed by several experts, and on the basis of their feedback, a shortlist consisting of 8 works was compiled. The shortlist is presented in alphabetical order. Academic work Accessory Liability by Paul S. Davies. The work is devoted to the analysis of accessory liability in English private law, which has received far less attention than accessory liability in the criminal law context. This book supports the idea of adopting a unifying view of common principles of accessory liability in the private law context. A major argument of the book is that similar principles underpin the imposition of liability upon an accessory regardless of the nature of the primary wrong, e.g. tort, breach of a contract, or breach of a fiduciary duty. The author is Professor of Commercial Law, University College London, United Kingdom. Academic work Trademark and Unfair Competition Conflicts by Tim Dornis. The present work is devoted to the analysis of issues that emerge in a situation of a conflict between trademark law and competition law. The author has conducted a detailed analysis of these issues in a common law system using the example of US law and in a civil law system using the example of Germany, which is the biggest continental jurisdiction in the EU. The distinctive features of the work under consideration are, inter alia, the historical comparative method, which has helped to reveal the differences between approaches to regulation of trademarks and competition law in the US and the EU, as well as a detailed guidance for a modernized concept of jurisdictional self-restraint. The author is professor at the Faculty of Law, Leuphana University of Lüneburg, Germany. Academic work, The Europeanization of English Tort Law by Paula Gilliker. The author of the work under consideration had 2 main aims for her research: to identify sources of law in the domestic English tort law system which are of European origin, and to consider more broadly the consequences of introducing these new sources of law into the English common law legal tradition. The book examines the nature of legal development and how an area of law seen as typically English has been changed by exposure to civil law influences in EU law and the rights-based culture of the European Convention on Human Rights. Such analysis is all the more important and timely in 2017, when the UK is seeking to leave the European Union, Brexit, and the government is attempting to introduce legislation which determines how to deal with EU law already within the UK legal system. The author is Professor of Comparative Law at the University of Bristol, United Kingdom. Academic work Il contratto di affidamento fiduciario by Maurizio Lupoi. The work under consideration is devoted to the research of the tensions between the English law of trusts and the continental law approach to this concept. This work continues the series of authors' publications devoted to different aspects of trust law, which has been the major subject of his academic work throughout his life. In his books, including the present one nominated for the St. Petersburg International Legal Forum Private Law Prize, the author shows that there are no compelling reasons for continental jurisdictions to reject the concept of trust. The author's arguments developed in his academic works contributed, inter alia, to the fact that in 1992, Italy became the first civil law jurisdiction to ratify the 1985 Hague Convention on the law applicable to trusts and on their recognition. The author is Professor Honoris Causa of the University of Genoa, Italy. Academic work, Proof of Causation in Tort Law by Alexander Steele. This book deals with an issue of tort law that is considered as fundamental in all legal systems: causation, the main focus being made not on causation as such, but rather on its proof. The author explores from a comparative legal perspective the requirement that the claimant must prove that the relevant aspect of the defendant's conduct was a cause of the claimant's injury, and critically examines the general rule of causation proof and the exceptions made to it in English, French, and German law, and to some extent in other common law jurisdictions. Although the author focuses only on certain jurisdictions, the subject matter is fundamental to all legal systems, and the author's analysis is therefore of a universal interest. The author is Associate Professor of Law, Oxford University, United Kingdom. Academic work, The Lex Mercatoria in Theory and Practice by Orsholia Tot. The present work is devoted to the analysis of Lex Mercatoria. The author evaluates the existing concepts of Lex Mercatoria and analyzes it as a universal, a-national, autonomous legal system. The work extends the discussion of the topic to public international law and draws parallels with the concept of customary international law, one of the elements of which is opinio juris. The author's book also discusses conflict of law issues and makes proposals on how parties and arbitrators may select the Lex Mercatoria as the governing law with greater certainty. The author is Assistant Professor in Commercial Law, the University of Nottingham, United Kingdom. Academic work, Exclusive Jurisdiction in Intellectual Property by Benedetta Ubertazzi. This work addresses the perception that exclusive jurisdiction is the only jurisdictional approach which is compatible with the territorial nature of intellectual property. The author argues that exclusive jurisdiction rules related to intellectual property rights cases are not only insufficiently supported by any of the arguments usually invoked in their favor, but actually are contrary to the public international law rules on the avoidance of a denial of justice and on the fundamental human right of access to a court. Therefore, in the author's opinion, exclusive jurisdiction should be abandoned with respect to infringement and validity claims involving either registered or unregistered IPRs. The author is full-tenured aggregate professor, School of Law, University of Milan Bicocca School of Law, Italy. Academic work, Money Awards in Contract Law by David Winterton. The present work is devoted to the analysis of money awards in contract law and common law jurisdictions. The author focuses on the decision Robinson versus Harmer, which identified that the function of pecuniary remedies is to compensate the claimant for loss suffered as a result of the breach by putting them in the position they would have been in had there not been a breach of contract. Winterton's thesis is that the law can best be explained and applied by developing a bifurcated account of the function of pecuniary remedies, which are either substitutionary or compensatory in effect. This thesis is developed throughout the book by close analysis of some leading cases from a variety of jurisdictions. The author is lecturing law, University of South Wales, Sydney, Australia. In March of 2018, the winner of this year's St. Petersburg International Legal Forum Private Law Prize was selected at the session of the Expert Committee in Paris. Committee members sealed an envelope with the winner's name in it.